Здравствуйте, с вами Frisco TV, я Святослав Седов, и сегодня мы с вами находимся на территории известнейшей школы юридической в Стэнфорде и берем интервью у Стива Allhoff, человека, который занимается патентованием здесь, в Силиконовой долине. Это специалист, который работает со стартапами, и я надеюсь, что он ответит на те вопросы, которые есть у многих стартаперов. Steve, thank you for coming.
Sure.
This sunny but cold day here.
Yes.
Here in Stanford, it's a little bit unusual in California to have such a weather. However, as all legal professionals, you must be adapted to any type of conditions, right?
Of course.
So my first question for you will be about yourself. So tell us about your company, about your job, what you're doing.
So I am a patent attorney with Wilson Hammond Holman. We're a patent prosecution firm. So we just do patent prosecution. I have a background in computer science. So our firm does exclusively high-tech patents. So that's we try and do mostly software and mostly hardware inventions. And then the computer science background that I have comes in handy. I handle most of the software type patents that we deal with. And that's mostly all our firm does. We try and stay focused on the prosecution, which is the acquisition of the patent. So that's the filing for maybe the utility patent or provisional patent, if you've heard those terms before. So the United States has really four good types of, intellectual property protection. So just going beyond patents. So we have patents, we have copyrights, we have trademarks, and then we have trade secrets, which are sort of a form of protection, but they're more exactly what they sound like. They're a secret. They're a particular way that you do business that sets you above the competition. And you just keep that secret. And if one of your employees misappropriates that, there's a whole body of law on what that means. If someone takes your secret and uses it, you can recover damages for that. So we'll focus mostly on the other three. That's patents, copyrights, and trademarks. So trademarks are sort of more focused on a brand. They are intended to provide consumers with some sort of understanding of the quality of your product without them having to go do some research. So for example, when you buy a pair of Nike shoes, you know about what level of quality to expect without having to go do research on this particular shoe. What is it made of? How is it formed? Is it a good shoe? You just know that brand is recognizable. They also go the other way. So in the United States, McDonald's is considered to be sort of a middle-grade hamburger company, and it's the same lack of quality you know and love is the joke that we always say, where it's, although it's not the best hamburger that you'll ever have, we know exactly what type of hamburger you're going to get, and so that's sort of what trademarks do. Their function is to help consumers identify exactly what type of quality and product they're going to get. They indicate a source. So this is a type of protection that you might use for your company holistically or for a particular product that your company makes. It doesn't actually protect any functionality, but it would be things like an iPod or something. You might want to create a very catchy brand, and you would get trademarks for that. Then the last two are patents and copyrights, and we consider these to be opposite sides of the same coin. There's something called the idea-expression dichotomy. If it's an idea, you probably want to get a patent on it. If it's some sort of expression of that idea, you probably want to get a copyright on that. So copyright is something like a song or some sort of artistic formulation that you've done, maybe the coloration that you're using or the pattern that you're using, something that's sort of an artistically expressive thing. That's something that you would get a copyright on. That protection is limited exactly to the embodiment that you have, the artistry that has gone into it, the particular design that you are using. So copyright, a lot of times we recommend for software. Sometimes is a very useful way to protect software, as you might use copyrights. But most of the time, inventions are best protected using patents. And that's what I do, is we do patent prosecution. And the catchphrase that we use for patents is anything under the sun made by man, with that last part being very important. It has to be made by man. So if you find a plant and you say, this is a brilliant plant that I have found growing in my garden, I would like to patent it, you will not get a patent. But if you cultivate the plant and you do some various different genetic modifications to that plant to create this new plant. Now it's made by man, so now you can get protection for it. But so dealing mostly with high tech and with software, almost everything that you create as an inventor is probably going to be made by man. That particular silicon chip that you've made was not just grown that way, and then the code that you've written didn't just happen one day. And so a lot of times there's not a whole lot of issue about it being whether it was made by man or not. So patents are probably the most recommended protection for whatever your invention is going to be. So the two types, there's the provisional application and a utility application. There are also design applications which are specifically for the design of something, which are a whole different type entirely. But between provisional and utility, the major difference in those is what you're actually getting. A utility application can mature into a full patent, which gives you the full rights of protection. A provisional application is effectively a bookmark. It gives you 1 year to convert your provisional application into a utility application. If you don't do anything with it after a year, it just expires, and with it go any rights that you possibly had. So we tend to advertise and offer provisional applications as sort of an immediate act of desperation. If your product is about to go to market and you want to get protection on it, or if some reason or other time is of the essence, we'll recommend you go forward with a provisional application, and then we'll try and convert that to a full utility application very shortly thereafter. Other than that, there isn't usually a very good motivation to go with a provisional application. In order to write a provisional application, you have to have some attempt at your claims and everything that you're going to disclose in your eventual utility patent. So the practice that we usually do for provisional applications is we just file a book of information with our rough attempt at claims and file that. And then when we convert that into a utility application, we pull from that information what eventually is going to form the utility application. But if you can provide us enough information to give us that book, you've given us enough to already write the utility application anyway. So if time is not of the essence, it is more financially sound to proceed with getting a full utility application and letting us file that, something that can actually mature into a full patent application, as opposed to just going with a provisional, which isn't going to turn into anything. You have to eventually convert that into a utility anyway, so it requires you to pay for a utility application anyway. If you have all the information ready, you know how the invention is going to work, you know everything about the background of the invention, you can give us all the information to enable this invention. If you already have all of that, you may as well proceed with a utility unless time is of the essence. And then perhaps a provisional application could be useful. So that we usually try and file a utility unless time is of the essence. Typically a territorial enforcement. If you get a United States patent, it is only enforceable in the United States. If you get a European Union patent, depending on which country in the European Union, it's only enforceable in that country. If you get a Russian patent, it would be just enforceable in Russia. So you have to file for a patent in each of the different countries that you wish to assert your rights. There are certain countries that are considered sort of the obvious choices. Those are like United States, those are China, maybe Brazil, countries that you expect most international businesses will want to operate in. If they can't operate in one of those big markets, there's really not a point in them operating at all, so oftentimes they just won't bother. So you can sort of get decent coverage over the entirety by picking these big 3 or 4 countries. A lot of different attorneys have opinions as to which ones they think are the big knockout countries. I kind of advise that you just sort of talk to an attorney about that if you're looking to figure out which ones you should file in. The solution, though, for making sure that you get all of your rights in all these different countries is something called the PCT, which is the Patent Cooperation Treaty. Most countries in the world, there are a few exceptions that have variations on how they work with this, have agreed to this Patent Cooperation Treaty. And the way that it works is you file with one of the various members of the PCT. And then within 30 months, you enter the national stage for each of those different countries. There's a fee associated with that. It's basically like filing a patent in each one of these different countries. But you get the benefit of the filing date where you filed first, which is useful because the way that patents work is it's sort of the first one to file for the invention gets the invention. And so the earlier filing date that you can get, the more likely you are to have a claim that stands against subsequent inventions. So by using this PCT, you can file once in, say, Russia or in the United States or wherever else your company is, and then at some point later, if it becomes relevant for you to bring your patent into another country where you'd like to assert your rights, you can do so. It's not an infinite window that you have to do this. You only have 30 months to do that, but you have some time in which you can determine, okay, the United States was somewhere I want it to be, and now I want to file and enter the national stage in another country. And that's sort of something you want to talk to your attorney about, is the timing for that. There are different fees associated with waiting longer. There are some diminishing of rights if you wait longer. So it's important to make sure you speak with your attorney that you hire that's filing this patent for you to figure out how quickly you need to enter the national stage in these other countries and to figure out which ones are advantageous for you to enter. The steps to file a patent or provisional application are largely the same. We need from you largely the specification, which is the details of how your invention works. A patent application is made up of three parts. It has drawings, it has the specification, which is all of the detailed explanation of how your invention works, and it has claims. From you, the inventor, we would most likely need a basic discussion of what your invention is. Part of my education was learning about this technology, and I try and stay up to date on the education and the technologies even today, so that when I receive an invention disclosure from an inventor, which is sort of the detailed specification about what the invention is, I can understand it very quickly without having to take your time to explain to me the rudimentary components of your invention. Some figures might be useful too if you think you have some flow charts that explain how your invention works, or maybe some schematics that show me the circuitry of your invention. These things would be very useful for my understanding to try and understand what it is. The process then is that I will take these things and I will create some further figures to give sort of a background or a scope of the invention. Then I will sort of massage what you've given me into a more complete description of what the invention is. And then I will draft a claim set. There are independent claims and there are dependent claims. The independent claim is sort of, this is what the invention is. And the dependent claims are modifications on that. So for example, you might say a chair, and then a dependent claim would be a chair with 4 legs, a chair with 4 legs and a back, a chair with 4 legs and a back that reclines, and slowly you add on all these additional features. But you always want to start with whatever you think is the most broad invention that you have created. And these claims are the most important part of the invention, or the application rather. These claims are what your rights are. Whatever goes in the specification goes towards enabling your invention, but ultimately these claims are what we need to get right. They are an exclusionary right. They don't entitle you to do anything, but they entitle you to prevent others from doing that something. So when we work with you, we will eventually send you a draft of the application. Look at the claims and make sure that you feel like that captures the invention. That is your first step. And after that, make sure that the specification doesn't have any obvious blunders, things that we've misstated or unclearly stated that you'd like to correct. And then take a look at the figures and make sure that you understand them, that they match up. If all of that matches up, then the next stage is we actually file the application. We would file it with the United States Patent and Trademark Office, the USPTO. There are 3 different ways in which you can declare your entity status. You can be a regular large entity, which would be something like Apple or Cisco or Google. They're large entities and they get no break. The fee is whatever it is. There is small entity, which is less than 500 employees with no requirement to assign, transfer, otherwise provide your patent to one of these large entity companies. And the last one is micro-entity, which is you're a solo inventor and it would just be neat to have this patent on your wall. You have no intent of commercializing it ever. So most startups will fall into this small entity category. But again, you might want to talk with your attorney and make sure that that's the right choice for you, because if you plan to exit to a large company, there are some different changes and things that you'll have to do on the back end to make your patent acquirable by one of these large entities. So these are things that your attorneys will be able to talk with you. As far as the amounts go for them, they do change somewhat regularly. It's best to just simply take a look at what the fee schedule is. Right now it's $270 to file in the United States for a large entity, or $70 if you're a small entity. So it's quite a price break, but that can change. So make sure you check and figure out what the is before you agree to file your application. And then there is also some drafting time on the attorney's part. That can range. I think probably the average cost you would expect to file a full utility application in the United States is about $9,000. That can vary down to about $6,000 if you're a smaller entity. but that's just sort of the range. As far as the PCT goes, that number varies entirely based on which countries you wish to file in. I really can't have a ballpark for you on that one. So when you have something that's a mechanical invention, the application is usually much easier to show the examiner at the patent office what exactly the invention is. I can point to it and say, see this circuit here, something about this connection makes the invention, the capacitor allows the charge to hold longer, something, I don't know, very fundamental to whatever the hardware is, but you can explain exactly what mechanically is the improvement here. So those are very easy to write. They're usually not too hard. Software patents have been a little bit more tricky as of late in the United States. There was a case that challenged whether or not software patents were largely just an idea that you somehow taken from something you used to do in your mind and now you're doing it in a computer. And they've largely said that's not going to be novel. You have to do something more than that. And the test has largely become, what is the functional improvement that this software causes on the underlying hardware? So if something about your sort algorithm now runs more efficiently and the processor only has to run, 200 cycles as opposed to 2,000 cycles, that's a functional improvement. If there's something about the way that it caches memory, there are less requests to secondary memory and so it's faster, that's an improvement to functionality. If there's something about you can emulate 3 or 4 different devices where before you had to have separate computers for each of them, that's an improvement to functionality. So this is sort of what we're aiming after, is trying to identify what is the functional improvement in the software. So a mechanical invention, we would claim it as a system for whatever your invention does. Software, we can still claim it as a system for, but we would claim it as a processor and memory configured to, and then it's all about the method. And that's mostly how software patents are claimed. It's a method for doing something. So if you can think about your invention, if it's a mechanical invention, you can just think of it as a system, very straightforward as you would expect. Show me where the processor is, show me where all the different components of your invention are, show me how they all integrate together to perform some sort of functionality. If it's a software invention, your task is to tell me what the routine is. What are all of the functional steps to it? How do you receive the input? Where does the input go? What do you do to the input? How does the output come back out again? Do you store the input? Do you pass the input off? Do you display the input? How do you display the input? Give me all of that. I need to know all of the steps to your method. And it does feel like it's a very narrow patent then. But there's sort of this doctrine that we have once you come to the litigation side of things called the doctrine of equivalence. And it largely asks, if you're doing functionally the same thing, we go ahead and read infringement on those other inventions. So it's okay to have a very narrow claim that calls out a particular protocol, as long as that protocol is largely interchangeable. Or if you say, we're doing it in Java, and someone else is doing it in C++, and someone else is doing it in another language that is functionally equivalent, you're not going to be stuck to just that one language unless someone can identify some sort of functional improvement over that language. It's an area that we're pretty comfortable drafting claims to include these specificities. It gives enough functional support that allows the patent to be issued, and it's not so narrowing that it precludes you from ever finding anybody who's infringing on your patent. So that's getting now into patent litigation, which is very, very costly. Your first step is probably to find an attorney who can write a cease and desist letter for you, which would just sort of ask whoever you think is infringing to please stop or to license your invention. Sometimes that can make people a little bit uncomfortable when they're being told that we think that you infringe. It's something you want to be very mindful about. Again, we don't practice patent litigation, so this is not getting out of sort of the areas that we would be able to help with, but you tend to talk to some of the larger firms in the Bay Area are the ones that handle litigation because the budget's very expensive. I think last I looked, it's about $5 million and up in order to pursue patent litigation. There is another new option that's called an inter-party review, and this just came out after the American Invents Act in 2013, and this allows any party to tell the patent office, we think maybe you allowed this patent in error, and here is some prior art that we think shows or teaches the invention that you allowed the patent for. This is much cheaper. It's more, I think it's $100,000 to file an inter-party review right now. So that's, from $5 million, considerably cheaper. Again, it's something that would challenge a patent if someone is trying to patent for your invention. If you think that somebody is using your invention, though, your options are still more limited to the cease and desist letter or to sue for infringement, which can be very expensive. So that is something that you want to try and get an attorney involved in to ask them what is the best recourse to handle this to make sure that you don't accidentally start a massive litigation against a party you didn't mean to. There are many ways to go about handling that conversation besides just going to court. But as far as the options that the legal system offers you, it's pretty exclusively going straight to litigation. It's there. I don't know that it's always the best option. It can be very costly. It can be very cantankerous. It's a very adversarial model in the United States. And so if you find that someone big is infringing on your patent, be prepared for them to not be very happy with you. And if at some point in the future you think they might be an exit route for you, you probably don't want to have the first conversation with them being a court summons. So it's very mindful that you keep in mind what are all these different steps that you might possibly take before actually straight up suing somebody in court. But these are things that you want to talk to an attorney about to get the best advice, and they're very case by case. Again, these are very case-by-case things. They absolutely depend on what your situation is, who the party is that's contacting you, how much capital you have to fight this sort of thing. So just this is general. I would say you would need to definitely talk to an attorney as soon as you get one of these to understand what is the best course of action for you. But there are many that you can take. So for example, if someone contacts you and says, I believe that you are infringing my invention, I would like you to take a license. You might find that the amount they want for their license is satisfactory, and you could go ahead and take it and just negotiate for whatever that license deal is, and that could resolve the issue. You might decide that this is absurd. The patent that they have makes no sense at all. It should have never been issued in the first place, and that was what I was saying about the inter partes review. You might want to go ahead and file one of those and show the patent office this patent should not have been allowed. This was known technology when this person filed for the patent. You might also just simply say, I don't know who you are. I don't think this is going to be anything that you're going to assert. I think you're a troll, in which case your options kind of get a little bit, there's sort of that ignore it approach, which is not at all something you should do. Let me repeat that. Do not ignore it, but talk to your attorney and figure out what is the best approach. There might be some gamesmanship to how this is really playing out. Sometimes these notices from a troll that say you're infringing my invention are a little bit hide the ball. That's not really what they're after. They might be playing some sort of game, and it is wise of you to figure out what your rights are in the situation, to figure out, do you take the license? Do you battle the license? Can you afford to battle the license? Is there maybe some other negotiation that you can have with this party to figure out how to amicably come to an agreement? Maybe geographically, okay, if you wish to take all of Europe, I'll take all of the United States. There are different agreements that you can reach before it actually comes to going to court. So there's a lot of due diligence that you would want to do to make sure that the patent that you are getting, the chain of assignment from inventor to now that you're purchasing it has full integrity, to make sure that you aren't purchasing smoke effectively. There's something called a quitclaim license that exists for property, and that basically says, I give to you all of the rights that I have. Well, if they didn't have any rights to begin with, you've purchased zero rights. So make sure that the chain of title is intact. You also want to make sure that if it's a patent that hasn't fully issued, so it's a patent pending or patent application, take a look at it and evaluate how solid you think this is. Take a look at some of the rejections that you've received for it. Does it look like it's headed places? Does it look like it's probably going to die without ever issuing? Again, a patent's only worth something if it issues. If it's just in publication, it's anticipated that you are going to argue it and get a patent allowed, but it's still not a patent until it is issued. I guess some other considerations too to make is sort of, who are all the parties that have a right to this patent? If there are several inventors, you would have to get several inventors to assign you the rights to the patent, or else you would share the rights to that patent with the inventor. A lot of companies just have a policy now of saying, before you even file the application, we're going to assign it concurrently to filing for the application. That's probably best practice that we recommend, is the inventors can receive whatever bonus you feel is appropriate to give them for their invention, and they can have their credit on the invention itself, but that patent should be assigned to the company itself, just for bookkeeping, for accounting, and for a lot of practical reasons. That's an easier process. Some inventors feel like they want to keep it, that it's theirs, but I think most conversations can be had to explain to an inventor why it's in their financial interest, and for the best to see their product actually come to market, to have it being held by a larger corporation that can actually find a way to monetize that patent.
Okay, thanks. What are steps which I have to undertake to sell the patent? I want to sell something, and my company owns the patent. Now, what I have to do to sell it?
So as long as you have all of the inventors or all of the owners who have this patent, and you can show clear chain of title, if you can find a party on your own who is interested in buying that patent, it's simply a matter of having the documents for assignment submitted to the USPTO. And then with that, you would probably sign other documents for whatever the agreement is for funds that you would agree to. And that's really all it is. Assignment of a patent is very simple. It's a property right that you can freely assign to whomever you want to. With exception, there are some technologies that are a little bit more protected. So those are high encryption, satellites, and I think nuclear weapons are also ones that are not so freely assignable. You have to show citizenship in order to transfer those. But for the most part, inventions are freely assignable. As long as you file this assignment document and everything else works out between the two parties, you can assign a patent. And that's pretty much it. There are a number of search agencies that exist also that will help you find parties that might be interested in acquiring your patent too. I don't actually know the names of any of those at the top of my head, but most of us can find them for you. Most of patent attorneys can find them for you and find parties that are interested in acquiring these patents, or at least can get you into one of these services. But there's usually a fee. There's sort of a brokerage fee associated with that. So arguably, the inter-parties review that just came to about in 2013 has been a huge step for curbing troll behavior. As a lot of times the practice with trolls is that they will say, I have this patent, it is infringed by your practices, and we're going to need a license. And they just send messages to lots of people, and they figure out just the exact amount to ask you for in licensing that you are comfortable paying that over taking them to court. But because this inter-parties review is so much cheaper, a lot of companies have started challenging these trolls with these inter-parties reviews, and it has the potential to kill your patent entirely. So if you're a troll and you are exerting a questionable patent against some of these small startups, you're sort of playing a game of Minesweeper. You might accidentally find a startup that wants to go after you and does want to challenge the fact that they think you don't have a valid patent. And if they win, your patent's dead. And as a troll, that's a very scary thing. This is an investment in them buying this patent. They don't want to risk going out and suing infringers if they don't think their patent will stand up. And so they have to be very, and there's been a somewhat of a chilling effect on troll behavior because of this, where a lot of trolls are starting to be very careful about which patents they choose to assert. So they're very sure that they're a good patent before they go and assert it. So this takes care of sort of the weak ones, the ones that patent should have never been issued, it's way too broad, everyone falls into it, it's just a trap. Those patents are sort of being knocked down by the inter-party review. The ones that are legitimate, the ones that are solid patents that were rightfully issued and do in fact teach the invention, there isn't going to be a whole lot of protection against the small startups, because that is what the patent system was intended to do. It was intended to give the holder of a patent the right to exclude others from practicing that invention. This is what a troll is doing. The part that makes people a little bit sick about this whole thing is that the troll is not actually advancing arts and sciences in any way. They are just a gatekeeper, or troll under the bridge. That's where that comes from, is they are there to just take a tax off of people who are actually inventing, who are actually bringing a product to market. There is discussion about how to do that, but the difficulty with that is that there are companies that also have these patents, that in the course of developing some product, they came across another way of doing this unrelated thing that they're not ready to bring to market or is not really part of their core competency, but they have that patent. They should probably be entitled to exercise that patent. After all, they thought of it. But for all intents and purposes, they look exactly the same. They are an entity that has a patent, is not actually making the invention related to that patent, and they are enforcing it against others. If you're a troll and that's all you're doing, we don't like you very much, because you are there interfering with companies' abilities to advance arts and science. If you are someone big who during the course of spending your own R&D money stumbled upon something that isn't really what you do, but is nonetheless an invention, I do sort of feel like that company has a right to that invention. They invented it just like everyone else does, and it's their right to decide if they want to bring it to market or not. So figuring out how to paint that line where you're actually a big company, you invented it, you found it on accident, it's not something you plan to go forward with, but you probably do have a right to enforce it, versus you bought it from someone and you are just going around trying to collect money from people. Figuring out how to distinguish between those two cleanly and using law is extremely tricky, and there are efforts being made, but there doesn't appear to be any clear solution on the horizon just yet. In the United States and Europe as well, there is a on-sale bar as well as a disclosure bar. If you have told somebody about what your invention is before you file for a patent application, you lose any and all rights to that patent application. unless it's a private disclosure, which is one of those non-disclosure agreements. So if you have some of those in place, you're probably going to be safe. But if you're going to trade shows, if you're going to startup conventions where you're trying to show off what your company is and what your product is, you want to have something filed before then, because that will evaporate your rights. So if you come here and you know you're going to start going to these different startup shows and you're going to start showing off your invention and your product and your company, it's probably very wise that you speak to one of us very quickly. And this is oftentimes when provisional applications come in. You come to us on a Monday, you're going to a convention this weekend. We don't have time to write a full application for you, so we'll file a provisional application, at least get your invention saved. So really as quickly as possible. If you think that you're going to be telling other people about something that is inventive that you may at some point want to get a patent on in the future, either only tell people who you signed a non-disclosure agreement with, or make sure you have that patent filed before you start telling people, or your rights will evaporate.
Excellent. Thank you very much for that interview. And I hope I will be able to take another one. And you are not too tired. And by the end of the interview, could you tell something to our viewers and preferably say them goodbye in Russian?
Sure.
You know how to do that?
Baka-baka? Yeah. What's thank you?
You also can say «до свидания».
Oh, okay. Good. That works. Okay. До свидания.
Всего вам доброго. Спасибо за ваше внимание. С вами был Святослав Седов, Стив Алхая. И ищите нас в интернете, смотрите наш канал. Там будет много чего интересного. Всего доброго. До новых встреч.